This is Laws 12062, Alternative Dispute Resolution. We're into week 5. We're talking about conciliation. I'd like to talk firstly about the assessment piece. The assessment will be recorded through some form of audiovisual program or platform. My preference is Zoom simply because I'm used to it, and that's what we're using here. The reason that I chose 40 minutes is practical as much as anything else. It's a reasonable length of time for you to show us how good you are at the task, but it's also the limit of what you can record free of charge on your Zoom license. If you go beyond 40 minutes, you need to upgrade your Zoom license to professional, which I think is quite cheap. It's $10 a month or so, but I don't think you need to go beyond that. You can record your session for as long as you like. If you think that you can adequately deal with the task in 20 or 25 minutes, that's fine. But I expect realistically for you to show us all of your skills, it will probably be at least 30 minutes. So somewhere between that 30 and 40 minute mark would be ideal, I should think. So if there are any questions, please feel free to unmute your microphones and ask the question, or come in using the chat facility down the bottom. All right, now conciliation, and I do want to talk about some practical skills later tonight. But firstly, some commentary in relation to conciliation. You may have seen many references to NADRAC, and that's the National Alternative Dispute Resolution Advisory Council, or at least it was. It was established as an independent non-statutory body. It was established in '95. You'll recall that the ADR was really is a brand new topic, so it was sort of at the forefront, and it provided some expert policy decisions and recommendations for the Attorney General on development of ADR generally. It was promoted, so it was used as a vehicle to promote ADR, and in many ways it's been very successful. However, it was concluded late in 2013. There was a decision made, policy decision, to simplify and streamline the business of government. So that work has now been absorbed into the Federal Attorney General's Department. And the official reason was many of these statutory bodies have outlived their original purpose or are not focused on the government's policy priorities. As a result, their work is best carried out by the relevant government department or agency. So to my mind, it's a pity that NADRAC has gone, but it did establish the Mediator Standards Board and the National Mediator Accreditation System. I would encourage all of you to consider becoming a nationally accredited mediator, and I think you'll find it a worthwhile exercise. I use my mediation, I'm nationally accredited, and I use it mostly in the work that I do in the tribunal, but it is available to you to use generally beyond that in private practice, and indeed, sorry, you can go further and become registered as a family law practitioner in the ADR field so that you can issue family law certificates to enable people to take the further step and initiate proceedings in relation to children in the family law Federal Circuit Court or the Family Law Court. So I'd encourage you to consider that, and that's part of the what was left behind through NADRAC, and that's still going. The accreditation system still works, but it's done through the Attorney General's Department. So at the Commonwealth level, the Access to Justice Task Force produced a report in 2009, and that report, which led to the Civil Dispute Resolution Act of 2011, that's Commonwealth, required litigants to take genuine steps to resolve a dispute before commencing legal proceedings in the Federal Court or the Federal Circuit Court. Now, if you think about it, that's a huge step because ADR is now front and centre, and it's a preliminary requirement, it's a mandatory requirement in relation to many proceedings under the Civil Dispute Resolution Act at a Commonwealth level. But well before that, we had conciliation. And conciliation has been adopted by a number of organisations as its preferred dispute resolution process. Now I'll go through a list. Firstly, the Australian Human Rights Commission, disputes with respect to age discrimination, asylum seekers, refugees, children's rights, disability rights, race discrimination, freedoms, sex discrimination. So that's all part of the Australian Human Rights Commission. We also have the Administrative Appeals Tribunal, the Family Court of Australia, the Fair Work Commission, the Superannuation Complaints Tribunal, the Financial Ombudsman Service, the Department of Justice and Attorney General, Office of the Commissioner for Body Corporate and Community Management, BCCM, and of course private organisations such as universities have some conciliation procedures. So you can see from that list that both at a Commonwealth and at a state level, conciliation is the preferred process in many instances. Now, the Conciliation and Arbitration Act was originally introduced into federal law way back in 1904. It has been repealed. It was repealed in 89. But as a result of that act, we originally had the Commonwealth Court of Conciliation and Arbitration, which dealt with the making of awards and hearing of disputes. And it was there to assist the parties in resolving the disputes. So even though I talk about ADR as a new phenomenon, there is this exception through that very aged piece of legislation. So what is conciliation? If we look at the definition for NADRAC, it is essentially mediation, but it's interventionist. And at the Queensland Civil and Administrative Tribunal, we talk about our conferences or a conciliation as a compulsory conference, or a COCO is the shorthand abbreviation that we use. So conciliation is a form of ADR process where, with the assistance of the conciliator, the parties need to do a number of things. Firstly, identify the issues. Well, that's the same as mediation. Develop options. That's the same. Consider alternatives. That's a little different, and I'll come back to that. And endeavour to reach an agreement, and that's a little bit different as well. Okay, so why do I say those last two are a little different between mediation and conciliation? Well, it really comes down to the role of the conciliator is much more interventionist and more proactive. So in its very pure form, mediation is a process where the mediator assists the parties to encourages the parties to develop their own options and doesn't generate the options. But in conciliation, the conciliator is much more interventionist. Indeed, in many instances with conciliation, the conciliator can provide advice, and indeed the conciliator may have some professional expertise in the area. So it's similar to mediation, but the conciliator's role is more directive and more advisory. This is relevant.
John, could I just ask a question? Mm-hmm. Does a conciliator have to be legally qualified?
No, absolutely not. That's a good question. No, they don't. And many nationally accredited mediators are not legally qualified. And that's one of the hallmarks of the ADR process. One of the advantages to that is that you can now have people who have industry expertise providing the advisory role that we talk about is in conciliation. And that doesn't have to be a lawyer. It often is, but doesn't have to be. So thank you, John. So conciliation might be voluntary, it might be court-ordered, it might be required as part of a contract, or it might be part of the process of a court or tribunal or government agency. But it's becoming more widespread. All right, so this is relevant for your assessment piece in this sense. With your assessment, I'd like you to nominate as part of your introduction whether you're conducting a mediation or a conciliation. And you'll need to describe the process for the parties, and that gives me an opportunity to see if you've described it the way I would like you to describe it. And then, having nominated that you're doing a mediation or a conciliation, it gives me a chance to see if you've followed the rules, so to speak. And you need to consider when conciliation is appropriate as opposed to mediation. So where do you think, I'll just ask for some thoughts now, where do you think it might be more appropriate to consider a conciliation rather than a mediation? Are there any thoughts? So mediation is less interventionist. It's more empowering, is in a sense, the parties. It's not to say the parties are disempowered in conciliation. You've always got to ensure the parties own their own dispute. But just generally, there are some advantages to having a conciliation in certain circumstances. When the parties are struggling to come to an agreement, says Brad, yes, so perhaps having someone that can intervene, provide that advisory role might be very useful if there's a deadlock.
Workplace situations, John, when there's a large organisation perhaps and lots of parties involved?
Yes, it may be that. Now that's a good point, Erin, because having a conciliator can take control a bit more, grab the matter by the scruff of the neck, so to speak, but don't take control away from the parties in the dispute. So I'll be looking for that in the assessment work that you do to make sure that you're constantly referring it back to the parties.
In an employment matter, John?
Yeah, employment. I think employment is a very good one, and that's appropriate too, because the whole Conciliation and Arbitration Act 1904 was based around employment issues. So, yep, no, I agree with that, Tony.
I think basically it would depend upon what the dispute was about.
I think so. When the stakes are higher, says Forbes, I think that might be a fair comment. So I think probably in general terms, and it sounds a bit vague, but we might say that conciliation is suitable when the participants have a dispute that can benefit from the intervention of a third party to a greater degree. So that's a very general statement, but one that you might keep in mind. I think it's probably fair to say that if the dispute involves technical or legal issues, then it may be more appropriate to have a conciliation rather than a mediation. I mean, let's think about it. If you've got a dispute over someone's barking dog or noisy parties, maybe a mediation's a better way to go. Let the parties generate their own options. You don't need to get in there and generate the options or provide the advice or provide the technicalities. But if it's a technical issue, and I think many of you have raised that already, then maybe a conciliation is better.
Can you have a mix of both?
Look, you can, but it is important that you set the ground rules in your opening statement so the parties know where they stand and where you stand. So it is important that you're clear in that regard, and so that I know what you're proposing to do. That's where I'd like you to nominate in your opening whether it's a mediation or a conciliation. But you can mix between the two.
Yeah, well, I probably thought, like if you have a mediation and it's going along well, what I mean is, would it be okay to just suggest some things? Because at the end of the day, if you come to an agreement, the job's done, isn't it?
Yes, look, it is. In its pure form, in a mediation, the mediator doesn't make any suggestions. Lawyers have trouble with that. Lawyers are not generally not very good mediators in its pure form because we can't help it. We jump in, that's what we do. And I think many people are like that. So if your personality is such that you think, I won't be able to stop myself from jumping in and making suggestions, you'd probably better make it a conciliation. If your personality is more soothing, caring, nurturing, encouraging the parties to do the things, for themselves and providing that lovely platform, then mediation might be more suited to you. So it is a combination of the nature of the dispute. It's a combination of whether the parties can benefit from the intervention, and to some degree, it's a reflection of your own personality. So I hope that provides some guidance. It might be useful to have a conciliation where the parties want to keep certain discussions confidential, or where there was a mediation that was not successful, and now the parties want to take the matter to another level, which is more directive, without necessarily going to a tribunal hearing. So again, coming back to QCAT, in the building sphere, although it's changed just recently, the procedure has been for a long while that we have a mediation first, and if that's not successful, then we'll go to a COCO. So that's taking it up to another level where there is more direction at that conciliation level. Or it might be useful if the parties don't require legal representation. So it may be that the parties kind of want to know what the law is, but they don't have lawyers there, they haven't got legal advice, so maybe having a conciliation with a lawyer there who can provide some feedback and advice may actually suit the parties. Again, the big thing that you've got to be careful of is not to take control of the dispute and make it a hearing. Because if you make it a hearing, it's not a conciliation, and you have effectively failed in your primary role, which is to enable the parties to work out their own dispute. So that's going to be common in both a mediation and a conciliation. You've got it in a conciliation, you take it up a notch, but you don't go too far. So I know I'm talking in generalities, but keep that in mind, keep that phrase. This is your dispute, and it's an opportunity for you to resolve it and try and get them to talk to each other. And I'll be looking for that sort of stuff in the assessment.
John, it's Jenny here.
Yes, Jenny.
Hello, everyone. I just wonder, a conciliator, can they point reference to legal issues? Can they suggest in a conciliation that it's possible on one particular or a specific issue that there would be legal consequences to it? Is it possible for that?
Absolutely. And that is one of the roles of a conciliator to do it. But there are some things that you need to be careful of. So I've raised the issue of not taking the dispute away from the parties and making it a hearing. And so that's one issue. What's another issue about giving legal advice? Can anyone think about, yes, a conciliator can give the legal advice, but where do you need to be careful? So if in your assessment you've decided you're a lawyer conciliator...
Indemnity.
What was that, sorry, John?
Indemnity. Because if the conciliator isn't a legal practitioner, he's unlikely to have legal indemnity insurance, isn't he?
Absolutely. Personal liability is an issue. That could be, yes, thank you very much for that. Are there any other issues where a conciliator needs to be careful about providing legal advice during the course of the conciliation? So we've got two so far. One is you don't want it to become a hearing, and the second is you've got to be careful you don't get sued. Yes, Brad?
Also, don't to give the parties false expectations. True,
yes. Make sure that it's realistic. Do some reality testing, not fanciful.
I guess, John, too, they already probably have their own legal representatives, so you really need to make sure you're not stepping on any toes.
I like that answer. Yes, Erin. Make sure that you're not stepping on toes. Make sure that you say things like, this is simply my opinion. I'm not giving you, this is not necessarily the way in which another tribunal would consider the matter, etc. But just proffer an opinion and invite them to go and seek their own opinion. Forbes has come up with a good one, and that is perception of bias. I like that. It's very easy for you to slip into a role where one party is going to think you're against me, you're biased against me. You might be thinking that you're providing some assistance to help the parties, but it may not be perceived that way. And so what you don't want is a situation where even if the matter's resolved, there's a complaint comes in later saying you're biased. You know, I woke up the next morning and I thought, well, I only made this agreement because you told me that I'm not going to win this case. And now I've gone to see my lawyer. My lawyer says that what you said is a load of rubbish. So I want another conciliation. I want somebody who's not biased. So you've got to be very careful about that. So you can see that when you come to decide whether you're going to do a mediation or a conciliation, you need to ask yourself another question, and that is, am I going to take more risk by taking on a conciliation as opposed to a mediation. So there might be a risk-reward issue in terms of the assessment piece as well. All right, so I hope that's given you some ideas to think about in the difference between the two and what you're going to choose to do. Look, there are some commonalities. There are plenty of things that are common between a mediation and a conciliation. Obviously, when it's done properly, the conciliator does not take sides and does not make decisions. The conciliator does not tell the parties what decision to make, although they can make suggestions. That's a point of difference, but does not tell them what to do and does not determine who is right or wrong. So if you're going to be a conciliator in your mock assessment piece, you really need to make it clear what your role is. And part of that description, I would suggest, is to say to the parties, I'm not here as a judge or a jury. I'm not here as a tribunal member. I'm not here to determine the matter. So, and John asked the questions, do the parties have to agree that the outcome is binding on both sides? That's an excellent question. So you need to set that ground rule. What do we hope to achieve here? What will be the end result? Is it going to be binding? Is it going to be subject to a later ratification involving lawyers or a court? So it can be binding, but you need to set out the ground rules, I think is the fair thing. So it's optional, yes. Many mediation sessions which are run through the neighbourhood dispute resolution centres, they are strictly non-legally binding. So, and they tend to be, I suppose, generally at a lower level, and I don't mean that in a critical way, but generally perhaps at a lower level. And the mediator actually says that this is not going to be a legally binding agreement, but you can later take it to your lawyers and perhaps become a legally binding agreement. But the agreement you come to now will not be. In a conciliation, the agreement which is struck does tend to be binding. So if in your role you decide that you're going to be a conciliator, say in QCAT, with power to make orders, then you might say, well, not only is the agreement binding, but I can actually make an order. If that's what the parties agree, I will make it an order of the tribunal, and then it's beyond doubt that it's legally binding. So yeah, good question, John. Thank you very much for that. So it's a flexible process. Conciliation doesn't have to be in the traditional face-to-face, in the same room situation. It could be done through audio-visual means. It could be done by telephone. It could be done even through an exchange of letters. If they make an order, can that be judicially reviewable? No, I think Tony's right. It couldn't be judicially reviewable, but it could be subject to an appeal, perhaps, but it would be very difficult to do that. That's a good question, Jenny. Yeah, tribunals, judicial review. I'd need to look at that. So Jenny asks whether tribunals are.
I just say that because of.
Yes, Erin. Oh, sorry, Jenny.
Sorry.
Go ahead, Erin. Go ahead.
Oh, I was just reading another textbook today, John, on mediation. They were talking about conciliation, and they actually had some examples of cases, and some of those actually had been, they disagreed with what was going on. Some of them, it was actually heard in the Supreme Court then. Basically, it was talking about bias of the conciliator.
Yeah, and that's probably what you're getting at, Jenny.
I think through administrative law, which was quite a few semesters ago, I always remember that because it's been legislated, the tribunals have been legislatively created, it was bound, as long as you had standing. There was, of course, a few criteria which I can't think of at the moment. As long as you had standing and so forth, you're always open to that judicial review. So now I'm a bit confused.
let me look into that a bit more, and I'd certainly encourage some discussions in UCREW. I'm sorry I'm equivocating here, but could we discuss that on UCREW and put up some points? I'd certainly welcome it, and I'll do that as well. So thank you very much, Jenny. But I've made a note to come back to that. Thank you.
Thanks, guys.
Right, so we're talking about the flexible process of the conciliation. And right, so when we open the conciliation, it's going to look similar to mediation, and that is there will be an opening statement made by the conciliator, same sort of thing as the mediator. The role of the conciliator and the role of the participants will be explained, and the whole process will be explained, how long it will take, what's the general process, joint discussions followed by private sessions, another joint session, etc. So talk about the initial joint exploratory session and discussions. In your opening, try to encourage the parties to communicate directly with each other and continue to do that as you proceed. And then talk about the fact that you will have these private sessions. In your assessment piece, you really should ensure you have a private session with both of the parties and talk about what you do in those private sessions. I want to come back to that later tonight and generate some discussion about private sessions. So just talk about, in your opening, the procedures. Now, there are some advantages to conciliation. One of them is that disputes might be resolved more quickly than would be the case through a tribunal hearing. It may be still that parties find their own solutions. That's still an important hallmark of conciliation. And of course, that parties can maintain good relationships through improved communications. So, similar to a shuttle session, says Erin, ideally you would not have a shuttle unless you really had to, is my personal view. Try and keep the parties together as much as you can. Now, a shuttle is quite different to a private session, and I'd better explain that. Okay, so if we have a mediation or conciliation which is being run by shuttle, it essentially means that the parties are, for want of a better term, entrenched geographically in different locations. Now, I say different locations because generally it means different rooms within the same building. So it might be that they're in different 2 rooms from each other, but they're separated geographically by that space. And the mediator or conciliator moves between the 2. That is, shuttles between the 2. And the whole process goes like that. So there's really, at no stage do they join up in the same room at the same time. It's not a great way to do things. It defeats the purpose to some degree of having an ADR process where improved communications between the parties is one of the stated aims. So a shuttle might be useful if you have, for example, a huge power imbalance or you have issues of domestic violence. And you might set as the ground rule before the mediation starts, this will be a shuttle, I will move between the parties. Sometimes a mediation might start as a shuttle, but you can sense that the parties are moving towards each other to the point where it's safe to bring them into the same room, and then you conclude the matter in a more standard way, or it might go the other way. Things are starting to break down so badly that you're going to lose the parties. There'll be a walkout unless you convert it into a shuttle. So you need to be flexible in that regard. But that's what a shuttle is. That's where the parties are separated and the mediator or conciliator goes between the 2. A joint session is really just part of the process involved in a standard mediation or conciliation. So a standard mediation, let's say the mediator makes an opening statement, the parties then make their own respective opening statements, then you go into a joint exploratory session and discussion where you're trying to identify the issues and talk through issues. After that, you'll normally have the private sessions, which is where the mediator talks with one party and then talks to the other party. And rather than the mediator moving to different rooms like a shuttle situation, in a private session, it's normally the other way around. The mediator stays in the mediation room and simply invites one party to go outside for a while, have a break, while the mediator stays in the room with one party, and then they swap over. So does that make sense? So the actual geography of the situation is different between a shuttle and the private sessions that I've been talking about.
John, can I just go back to when you say you get the parties in, say, mediation or even conciliation, what happens to people who are just so shy that they do not want to talk and you don't have that opening statement from them?
Any thoughts on how you could encourage the parties that remain non-communicative to come out of their shells? Let's have a look on the chat facility. Thanks for the question, Erin. So what are some of the techniques we can use?
Could they have a friend to speak for them?
I like that. They could have a friend to speak. Thank you, John. Again, you want the parties to be take control of the dispute, so you don't want the friend to take over completely, but yes. So reassurance. So Anthony says reassure them. Brad says try and find some common ground. Tony says make them feel at home. These are all good things. Okay, so I hope that provides some ideas, Erin. I suppose you could also...
I was just thinking, John, of somebody who's extremely shy in that sense, where they've come from a very lopsided relationship in the sense where one's a very dominating person, the other one's very submissive. It's very hard to break that person out of that submissive state just in a couple of sessions, I would imagine.
Yes, true. And that might be a good reason to have a shuttle mediation as opposed to a standard mediation. Or you can ask some open questions is another way of doing things as well. All right, so thank you for that. Now, there are some specific forms of conciliation. I mentioned that before. I won't go on with that anymore. I've just got some notes to myself about contrasting conciliation and mediation, and I'll just run through them. So bearing in mind there's no one clear definitive statement of what mediation or conciliation is, often we have a hybrid between the two. The processes are, of course, very similar in that the dispute resolution practitioner is a neutral third party. The aim is to work towards resolution, to hear from the parties, to identify issues, generate options, consider alternatives, and try to reach an agreement. And neither conciliator or mediator have a determinative role. But it's different in that conciliation is often compulsory. In its pure form, mediation is always voluntary, but often conciliation is compulsory. And even we call that, so in QCAT, we call it a compulsory conference. The conciliator can make authoritative statements of the legal position or other expert statements. The conciliator may, with great caution, interrogate or cross-examine, but doing so guardedly using open-ended questions is preferred. You don't want it to become a grilling match of closed questions. You know, we talked about that before. So using open questions is always preferred. In a conciliation, the opinion of the conciliator may be imposed upon the parties to a degree, but very carefully. The conciliator can be proactive as intervening rather than being a passive participant in its pure form in mediation. And the mediator can encourage the parties in a more robust fashion. All right, so the mediator generally will ask relatively soft questions. The conciliator can be a little harder in general terms, if I can use that idea. All right, so the mediator is there to empower, and the conciliator may move between a power mode and the empowerment mode, to use some technical terms. All right, so we've got an idea, we've got a good idea now of what conciliation is all about. I know I've talked a lot of generalities, but there are some things that you really are expected to do as a conciliator, but there are many things where you simply can't go too far. Same as mediation. All right, so any questions? What I want to do before we wrap up for this evening is have a special statement, or just talk about private sessions. So we now know when private sessions come in. So we have our initial discussion, we're trying to talk about options, we're trying to generate different discussions about the issues. We probably get to a stage where it's useful just to break the parties up and have the private sessions. So after the first joint session, where the parties are encouraged to explore issues, you may need to call private sessions, and you will certainly do that in your assessment piece. In doing so, you should try to spend the same amount of time with both parties. Otherwise, you may appear to be biased. Now, it's not an exact science. Nobody will have a stopwatch on you. If you spend 4 minutes with one party and 6 with the other, nobody's going to care too much. So, but it's got to be reasonable. Now, what should you explain when you are going into these private sessions? So before you call a private session, and maybe even in your introduction, you're going to explain what the private session is all about. What are some of the things that you should explain to the parties before you actually go into the private session, just so they know what's going on?
Confidentiality in this.
Yeah.
Sorry, John.
Yes, exactly that. Confidentiality, unless they agree for it to be shared.
Excellent answers to both of you. Confidentiality, and my practice is always to say, whatever you tell me will remain confidential between us, and if you wish to make an offer, I will certainly encourage you to do that, but I won't make that offer for you, even if you ask me to. That's my general practice. All right? So anything that's said will remain confidential, yes?
I was just going to ask, John, I was reading stuff on mediation today, and it was talking about loop back and loop forward. Can you explain what that is at all?
Loop,
L-O-P, forward, and loop backwards.
No, I don't know what that actual term means, loop forward and loop backwards. But I mean, another term that is used around QCAT, which Judge Kingham created, was be light on your feet, and it might be along those lines. So you've got to be mentally agile during the whole process. It's actually quite draining. By the end of it, if you do it properly, you're going to be pretty exhausted after 40 minutes, because you're constantly trying to think about different avenues, think about different ways that you can approach the problem, encourage the parties, change the pace, change your tone, do all those sorts of things. So maybe, and I'm only guessing, maybe that loop forward, loop backwards is a reference to the mental agility that you need to demonstrate during the process. If anyone has a different answer on that, please let me know. All right. So when you go into the private session, you should just explain what it is, and you could say, well, now I'm going to meet privately with both of you. We call this a private session. What you tell me during that session will remain confidential. The other party will be invited to wait outside. I'll show you to the restrooms. I'll show you where you can make some tea or coffee. I can indicate to you the private session will probably take about 5 minutes, and I'll spend similar time with both parties. So I physically then leave one of the parties in the room and say, I'll be back shortly, invite the other party to come with me, and I'll take them out to an appropriate area so that they're accommodated and settled down, so they know they're being looked after. I'll then go back into the private session and generally ask, there's a few things that I try to do during that private session. One is a debrief. How are you going so far? How are you feeling about the process? And generally you see parties that are starting to have their anxiety levels built up during the joint session. You ask them that question at the start of the private session, and they kind of start to relax. And this is where you have your opportunity to be there as Professor Ashman calls it, your new best friend. So you're the good guy who's coming in and saying, how are you feeling about this? Are we working? Are we getting there? You know, you're feeling good, blah, blah, blah. So try and encourage them. Cerebral gymnastics, says John. Yes, I like that term. So debrief is one of the first things you'll do during that private session. You might ask them how they're feeling about the process. Good cop, bad cop, yeah, to a degree. Bit of acting goes on. I like to lower the tone. Just speak more softly. Just almost, sometimes it's almost whispering. How you doing? We're doing okay. You know, just positive body language, all that sort of stuff. Maybe explore some of the issues that haven't been raised in the joint meeting. And sometimes it might be it occurred to me while we were discussing things that nobody's really talked about having, this or that or whatever it might be. So just planting a seed. Plant a seed and see if they run with it. So, and then identify the issues of major concern. You know, we had 4 matters on our agenda item, but it really does seem to me that item number 2, that's the one that really affects you the most, isn't it? Try and get them to speak to you about that, and it might provide you with an opportunity to work with them to create an offer which can be used in the next joint session, not by you, but by them. So try to encourage some positive progress. Okay, you've come so far, you've done really well. I think we can get there. I think we can resolve this, don't you? You know, it's their dispute, but we're kind of taking a common interest in it. Then we go on to say, all right, well, let's see if we can put something together, shall we? And I say we, but I don't really mean we, do I? I mean you. So let's see if we can put something together. What do you think? What do you think would be an appropriate way to resolve this? Are you prepared to put an offer that when we go back into joint session, you'd be comfortable to live with? You might remind them comments that you made at the start, that rarely would people be happy with the resolution, but they might be prepared to live with the resolution. And if both parties are a little bit unhappy, then maybe we've come to the right result. It's important that when you're encouraging the parties to frame an offer, that you're going to have an apples type scenario. You know, if your offers are kind of different in nature, it's going to be very hard to come to an agreement. So it's your opportunity to see if the parties are willing to frame an offer that might be consistent with the way in which the other side will frame the offer. So it might be that we're talking percentages or dollar terms or absolute terms or relative terms. So maybe do some coaching, maybe do some reality testing. What do I mean by reality testing? You know, I know it's important to you that this occurs, but is that really going to happen? Is that something that can genuinely happen in your situation? And get them to think about it. And encourage the parties to think about what is their best alternatives. No, I knew that, Jenny. Encourage the parties to think about what is their best alternative to a negotiated agreement, the BATNA. So provide some thoughts with respect to a likely outcome. That's where the advisory bit comes in, and then consider the ramifications of not settling the matter. So that's my list of the sorts of things that you might do in the private session and the sorts of things that you might consider. Did I miss any? Are there any things that need to be clarified? Don't tell me I got everything. All right, so we're all experts on private sessions. I'd practice it and just practice all this because what you need to do is essentially on show day, put it all together. So practice these individual components as you go. Okay, well, you've been very patient with me tonight. I know I've spoken a lot, sorry. Before we wrap up, are there any questions, comments? Probably easier said than done. All right. We might, I'll stop the recording now. Thank you very much for your attendance.